Okay, so welcome everyone to the first Ross Parsons Centre for Commercial, Corporate and Taxation Law webinar. So the Ross Parsons Centre is a centre here at Sydney Law School, and for many years we've been running a series of seminars, which now of course are webinars, which we call the Downtown Law and Business series. It was started by Professor Jennifer Hill many years ago, and the goal is for us to interact with the business community, interact with the general community, to share some of the research that some of our academics are doing and some of our academic colleagues are doing. And so these sessions, we try to make them as practical as possible to raise issues that we think are going to be of interest to the profession. And so what we tend to do in these sessions is we also have a practitioner as a commentator. So our presenter for tonight is Adam Waldman. Adam is a new staff member here at Sydney Law School. He's teaching torts and contracts and also introduction to property and commercial law, which includes the PPSA. Adam's got a deep interest in the PPSA because he's also doing his PhD here at Sydney Law School on the PPSA and its interaction with equity. Our commentator for tonight is Nicholas Commons. Nicholas is an associate at the law firm Hunt & Hunt here in its Sydney office. And Nicholas has been a lawyer for about 5 or 6 years, is it now, Nick?
It feels like at least a couple of decades, but
at least a couple of decades. Well, whenever
it's actually closer to 3 or 4, I think. But you know, we'll add a few anyway.
When we're dealing with PPS issues, I know it feels like a couple of decades, as I'm sure many people on the line could appreciate. And I've asked Nicholas along as a commentator because Nick's practice is a diverse commercial practice, and he's often dealing with some interesting PPS issues, which he shares with me. So I thought it would be interesting to have Nick's perspective on some of the practical issues and conceptual issues that Adam is going to take us through. So Adam's presentation tonight is going to be looking at some recent PPS cases. So in the description for this webinar, we've got the relevant case names, which you can have a look at. And we just thought that this was a good topic to look at some, what we think are some interesting PPSA cases. We certainly haven't had the flood of PPSA cases over the last year, but there's been a few interesting ones. And we've picked a couple of cases that we think might be of interest to the broader community and the profession. So in terms of asking questions and the timing, we will basically be discussing these issues through Adam's presentation for approximately 40-45 minutes or so, and then there'll be some time for general questions and answers at the end of that. If you do have questions as we're going through, you can either type your question in the Q&A box, which you'll find on your Zoom toolbar, or you can type the question in the chat box. So I'll be monitoring the questions as we go through, and then if there's a particularly pertinent question, I'll raise it with our presenters. Otherwise, we can deal with it towards the end. So thanks everyone for giving up your time. I know it's CPD season for those who are lawyers out there, and we've got a fantastic audience tonight. We've got over 250 registered, so that's tremendous for the first webinar. And I should also say that this is being recorded, so everyone who's registered to attend will get a copy of the recording, and we'll also post up that recording on the Sydney Law School podcast page and YouTube page. So over to you, Adam, if you'd like to share your screen.
Wonderful. I might start with a little introduction and then I'll share my slides. Thank you for the introduction, Jason. So this evening, I'm going to talk about 2 recent decisions of the Supreme Court of Victoria. They both happen to be by Justice Gard. I want to flag the kind of key value of these cases at the outset, which is that these, I think, are really both cases about identifying security interests. The earliest PPSA cases about identifying security interest often involved PPS leases, which, as you may be aware, don't have a security function, but are nonetheless treated as security interests. And of course, the seminal example people tend to think of is the case of Forge and General Electric, where you have a piece of equipment worth $40 million, which was lost due to register a financing statement of what was, in hindsight, a relatively clear-cut security interest. These cases, I think, kind of represent the next stage in Australian jurisprudence concerning identifying security interests. And that's about identifying interests on the margins. So I think the issues we're now looking at are no longer a lack of familiarity with the PPSA, but more about how does the Act apply to complex factual scenarios. So bearing that in mind, one provision that I would like to start by reviewing is section 12 of the PPSA. Now, section 12 defines the security interest, which is the core concept underlying the Act. And generally it said there are two types of security interest, the in substance security interest in section 12.1 and the deemed security interest in section 12.3. Starting with the in substance security interest, which I've got up on the slide, which you can hopefully all see here. Generally, this definition tends to be broken down into 4 different elements. Firstly, there must be a property interest. And one of the issues we'll look at today, does this need to be a recognized proprietary interest, or might the words an interest in personal property mean something a little bit wider? Then the interest must be in personal property. It must be provided for by a transaction. And this has been interpreted to mean a consensual interest, and is also something that will come up as we look through these cases today. And finally, the interest must, of course, secure payment or performance of an obligation. Now, the second type of security interest that I want to look at is the deemed security interest. There are 3 types of deemed security interest: transfers of accounts, commercial consignments, and PPS leases. And the reason they tend to be referred to as such is because they are treated as a security interest, regardless of whether they actually do have a security function. For today's purposes, I just want to focus on the latter, of which I've extracted some of the key parts of section 12.3 and 13 here. And that is the PPS lease. The PPS lease is comprehensively defined in section 12.3c and 13. And for today's purposes, the really key thing to note is that certain leases are treated as security interests, even where they do not have a security function. So with that said, let's jump into the first case that we're going to take a look at today, Jayfield Pty Ltd and Cussen. Now, this case concerns a dispute between 3 parties: Melded Fabrics, which operated a textile manufacturing business; Australian Comfort Group, which leased premises including a warehouse to Melded Fabrics. And the lease between Australian Comfort Group and Melded Fabrics contained clause 6.8, which I've summarised here on the slide. This clause said 2 things. A, Melded Fabrics had to remove its goods from the premises before the lease ended. And B, if Australian Comfort Group failed to remove its goods from the property, then Australian Comfort Group could remove them and store the goods elsewhere, charge a storage fee for doing so, and sell the goods if the storage fee was not paid. Now, the third party involved in this dispute was Jayfield. Jayfield leased goods to Melded Fabrics. Some of these goods were stored on the premises, which Melded Fabrics itself leased from Australian Comfort Group. What did these goods include? 11 40-foot shipping containers, plant, machinery, stock, and materials. And so the big thing to note, the goods in question took up a lot of space, they couldn't be easily removed, and the process of removing them and storing them elsewhere would have been very expensive. Now, as happens in PPSA cases, Melded Fabrics went into voluntary administration, and it then went into liquidation. Due to its failure to pay the rent, it was evicted from the premises, but when it abandoned the land, it left the goods on the land. So what then happens to the goods? Well, both the liquidators of Melded Fabrics and Jayfield claimed to be the rightful owners of the goods. Jayfield said, in short, it was the owner of the goods at common law, and thus it had the better right to them. The liquidators argued that the lease of the goods constituted a PPS lease that was not properly perfected by way of registration, and that meant that any rights Jayfield would have had in the goods vested in Melded Fabrics and thus vested in the liquidators. Now, when Australian Comfort Group repossessed the premises, this left it in a fairly unfortunate position. In short, it seems from the judgment that Australian Comfort Group really didn't want anything to do with the goods. It would have been very happy to get rid of them. However, it couldn't remove them and store them elsewhere because this would have been very difficult and expensive given their size, and also it didn't have anywhere else that it would have been commercial to put them. Further, it wasn't able to extricate itself from its position by simply getting one of the other parties to remove and take the goods. On the one hand, Australian Comfort Group felt that it couldn't release the goods to Jayfield because it thought the liquidators might have had the better right to those goods, and so if it released them, it would have exposed itself to a claim by the liquidators. On the other hand, it tried to let the liquidators sell the goods off, but Jayfield then prevented this by obtaining injunctive relief. So as Justice Garn said at paragraph 32, the result is that Australian Comfort Group found itself in possession of the stored goods, but caught in a dispute between Jayfield and the liquidators as to their ownership.
Sorry, Adam, can I just ask a quick question? And particularly for those in the audience who might be aware of PPS, but perhaps aren't fully across it as some others, could you quickly explain to the audience the concept of vesting and insolvency? What are you referring to there?
Yes, absolutely. So section 267 of the PPSA says that where a grantor of a security interest doesn't perfect its interest, now the usual way one perfects an interest is by registering a financing statement. Where they fail to perfect that interest, and then the grantor goes insolvent, the security interest vests in the grantor. So in summary, a secured party that doesn't make a registration of a financing statement is vulnerable to losing any interest that it might have in the property when the person who granted the security interest goes insolvent.
And they would still have a right, for example, to the value of that property, but it's a right against a company which is now in insolvency, and so they're not highly unlikely to get that money paid.
Yes, absolutely. So in this example, if Jayfield's interest did in fact vest, it would have still had a personal right against Melted Fabrics. Melted Fabrics is of course in liquidation, so that personal right from a commercial perspective just really isn't worth anything. So Australian Comfort Group is left in this tricky position. It's got possession of the goods. What does it then do? Australian Comfort Group chooses to leave the goods on the premises with the intention of charging storage costs once the ownership dispute is resolved. Who does it intend to charge those storage costs to? Well, whoever has the better claim. It then brings proceedings seeking orders under a piece of Victorian legislation, the Australian Consumer Law and Fair Trading Act, and it seeks orders authorising it to auction or dispose of the goods and then to keep the proceeds in order to satisfy those storage costs. Now, both parties dispute this. The liquidator disputes Australian Comfort Group claim to sell the property under the Australian Consumer Law Fair Trading Act. Jayfield also disputes the claim, but its claim is dismissed when it fails to pay for security for costs. So essentially Jayfield then falls away from this dispute, and we're left only with Australian Comfort Group and the liquidators who have good claims. And before we move on to the actual issues, I think an interesting note before we jump into them, particularly for practitioners perhaps, is just this. If Jayfield had dropped its claim earlier in the proceedings, then Australian Comfort Group would have probably quite happily let the liquidators just sell the goods off right from the beginning. But interestingly or tragically, depending on your perspective, by the time Jayfield's claim is actually dismissed, Australian Comfort Group has accrued significant storage charges. The liquidators don't want to pay these storage charges, and so the claim has to proceed to court. Now, the first issue that we are concerned with, what was the effect of clause 6.8 in the lease on the dispute, and how is this influenced by the PPSA? And the arguments were as follows. The liquidators said, clause 6.A gave rise to a security interest under section 12.1, and that security interest vested under section 267 because it was not perfected by way of registration. As we've just discussed, section 267 says that if a grantor becomes insolvent, which includes going into voluntary administration or liquidation like Melted Fabrics did, and the secured party doesn't perfect its security interest, then the security interest vests in the grantor. So the liquidators said clause 6.8 is a security interest in favour of Australian Comfort Group. Australian Comfort Group did not perfect this security interest, and thus any rights it might have had were lost. Australian Comfort Group made a different argument that essentially sought to avoid the PPSA issue here altogether. Australian Comfort Group said clause 6.8 was simply never enlivened at all because on its construction, clause 6.8 only had any effect if the goods were removed and stored elsewhere. But on the facts, the goods were not removed, they were just left on the premises. And the court accepted this constructional argument. And so the effect is it didn't need to deal with whether clause 6.8 gave rise to a security interest at all, because clause 6.8 was never enlivened, and thus essentially, from the court's perspective, it didn't matter. Now, the court then dealt with the basis upon which Australian Comfort Group could sell the goods and charge a storage fee, since clause 6.8 was not enlivened. This is of less interest to us since it's not a PPSA issue, but in short, the court said that it could dispose of the goods and charge a storage fee under that Victorian legislation, and also that an equitable lien arose over the goods in favour of Australian Comfort Group. So this then gives rise to the second PPSA issue, which we are concerned with. Did these rights that Australian Comfort Group have, being a statutory right to sell the goods and an equitable lien over the goods, did they constitute a security interest? If so, they would have vested in the liquidators under section 267. If these rights were not a security interest, then Australian Comfort Group could go ahead, sell the property and keep the proceeds in satisfaction of its storage costs. Now, the court held, respectfully, correctly in my view, that these rights were not a security interest because they did not constitute consensual rights. And the main reason for this comes from the definition in section 12.1, which we looked at earlier. A security interest means an interest in personal property provided for by a transaction. And a number of both Australian and overseas cases have interpreted those words provided for by a transaction to mean one that arises under a consensual agreement. So relying on this, the court said that since the statutory rights and the equitable rights arose automatically, they didn't arise under an agreement, they did not constitute a security interest. And so the ultimate conclusion of the case, Australian Comfort Group could sell the property, keep the proceeds to satisfy its storage costs. That then brings us to the second case, which we'll take a look at today, Tasman Logistics and Seaco. Now, once again, this is a dispute involving three parties. We've got SKM, which conducted a business of collecting recyclable waste for disposal. We've got Seaco, along with several other companies, and they leased shipping containers to SKM, in which it placed and collected the waste. The parties agreed. These leases of the shipping containers were PPS leases under section 12.3. And so as discussed, that means they're treated as a security interest despite the fact that they didn't have any security function. Another important thing to note is that here, Seaco did properly perfect its security interest by registering financing statements in respect of these leased containers. The third party involved in this case was Tasman Logistics, and as you might expect, it provided logistics services to SKM, and most importantly, this included storing the shipping containers which were the subject of this dispute. Now, the agreement between Tasman and SKM included clause 14a, which I've extracted on the slide. And in summary, it said, Tasman shall have a lien on the goods for all sums payable by SKM to Tasman. And for that purpose, Tasman shall have the right to sell any goods by public auction or private treaty. At general law, this clause would of course create what we would recognise as a contractual lien, which is a recognised contractual property interest to retain goods, and in this case, it also included a right to sell those goods. Now, similarly to the last case, SKM's business fails, it goes into liquidation, and it's later wound up. However, here, the liquidator disclaimed the lease with Seaco and any interest that it might have had in the shipping containers. However, at this time, Tasman is holding no less than 716 shipping containers for SKM, the bulk of which are owned by Seaco and those other companies. So what then happens to the containers? Seaco and the other companies seek to reclaim possession of them, but Tasman Logistics refused to relinquish the containers unless its unpaid storage fees were paid, and these fees were very significant, amounting to over $3.5 million as at the date of the judgment. Naturally, as one might expect, Seaco and the other companies refused to pay these storage fees, so proceedings are commenced to resolve two issues. Firstly, did Tasman Logistics or did Seaco and the other companies have priority in the containers? And then secondly, could Tasman dispose of the containers under that same Victorian legislation that happened to arise in the last case, the Australian Consumer Law and Fair Trading Act? Now, most of the judgment concerned that latter issue. Could Tasman dispose of the containers under the Victorian legislation? And in summary, the court said Tasman had a right to sell the goods under clause 14a. And what that meant was that it could only dispose of the containers under the Victorian legislation if no one was willing to buy the goods. That then brings us to the PPSA issue, which we are concerned with. Who had priority in these leased goods? Now, the court dealt with this issue under section 73(1) of the PPSA. And this is a provision which governs priority competitions between a security interest on the one hand and an interest which falls outside the scope of the Act on the other. So we might refer to that as a non-PPS interest or simply a non-security interest. Now, the court's analysis, Seaco and the other companies held a security interest, being their PPS leases. Tasman held an interest that was not a security interest, being its right to sell the containers under clause 14A of its contract. Now, in such cases, section 73(1) confers priority to the non-PPS interest, so in this case, Tasman's interest, where 5 requirements are met. 1A, the interest being the non-PPS interest must arise either non-consensually under statute or by operation of the general law. Secondly, it must arise in relation to providing goods or services in the ordinary course of business. Thirdly, it must be held by the person that provided those goods or services. Fourthly, priority must not be determined by some other law. And then finally, the interest must be acquired without knowledge that it breaches the secured party's security agreement. Now, why these 5 requirements? What is the provision actually trying to do at a somewhat high conceptual level? Unfortunately, the explanatory memorandum doesn't make this particularly clear. However, it does seem that section 73(1) seems to attempt to describe the elements of a common law possessory lien, and then also add the requirement that that lien must arise in the ordinary course of business. And perhaps we can infer this from the fact that the overseas equivalents of this provision simply confer priority to liens over goods that arise in the ordinary course of business. So returning to this dispute then between Seaco and Tasman, Tasman argued all of the requirements of 73(1) were met, and thus its non-security interest had priority due to section 73(1). Seaco and the other companies argued that the 4th requirement, being that in subsection D, was not satisfied. So they argued that the Victorian legislation determined priority, and thus that section 73(1) could not apply, such that Tasman was not conferred priority by this provision. Now, the court rejected that argument by Seaco. The court said Tasman's right to sell the goods did satisfy each of those components of section 73(1), and thus Tasman's non-PPS interest had priority over Seaco's and the others' security interests. Now, that was the resolution of the case, but respectfully, I would analyse this case somewhat differently to the court. The first thing I want to flag is that 14 was actually a security interest within the meaning of section 12(1). So if we think back to those 4 elements that I described earlier, here, the interest is a recognised property interest, being a contractual lien. It's in personal property, being the containers. It arises consensually because it was contained in the agreement with SKM, and it secured payment or performance of an obligation, that obligation being the payment of the storage costs. This is also consistent with another Australian case, which has treated a contractual lien as a security interest, being the case of NCO Finance and Australian Pacific Airports, which was a 2013 decision of the Federal Circuit Court. Following from that conclusion, that Tasman Logistics actually held a security interest rather than a non-PPS interest, I would argue that because it was a consensual interest, it does not arise by operation of law under section 73(1) AII. So I would argue here that section 73(1) was never enlivened at all. I would also flag that this is consistent with Canadian authority, which held that a similar contractual lien could not enjoy priority under the equivalent provision in the Alberta PPSA. In that case was CanSearch Resources and Region Resources, a 2017 case. So on my view, this is not a competition between a security interest and a non-PPS interest, but rather it's a competition between two perfected security interests. That would mean Section 73 has no role to play, and the priority competition should instead have been resolved by the provisions that concern competitions between two security interests. Unfortunately, the judgment doesn't contain sufficient facts to say whether this actually would have led to a different outcome, because it's not clear at what time the parties perfected their security interests. We do know that Seaco and the other companies registered financing statements, and we can tell that because Tasman Logistics had possession of the containers, it would have perfected its security interest by way of possession. Unfortunately, what we don't know is who did so first, and it's also not clear whether Seaco would have registered a PIMSI and whether it would have met those requirements. So, although I believe the reasoning that led to this outcome may not have been correct, it's not clear to say who actually would have won under the approach that I believe was the correct one. Now, before we move on to some key takeaways, I do want to emphasize that I don't mean to be overly critical of the court's reasoning, because the judgment makes very clear that Seaco and the other companies conceded that the relevant subsection in 73(1) applied. However, on my view, such a concession was probably not necessary, and if the issue was contested, it might have led to a different outcome, or at least a different way of coming to the same outcome. So that brings us to some key takeaways. And the first set of takeaways I want to think about concern the meaning of the in substance security interest under Section 12(1). There's really 3 points that I want to make here. Firstly, in the first case we looked at, Jayfield, the court affirmed that rights arising by operation of law are not security interests. That case concerned an equitable lien and a statutory right to dispose of goods. The court said that since neither of them arose consensually, neither of them could be a security interest within the meaning of Section 12(1). In that second case, Tasman Logistics, that I believe is an example of where there may have been a security interest, but it was not identified by the parties or in submissions on the facts. In that case, there was a contractual lien, and in my view, I would argue that contractual lien did give rise to a security interest. The third point I want to make comes back to the very first case we looked at, Jayfield, and it concerns the issue there that the court found the relevant contractual clause was never actually relied upon, and so the court in that case didn't have to decide whether what we might describe as a make-good clause could be a security interest. The clause in that case, it said the lessor could remove goods left on the premises and it could sell them to satisfy the costs of doing so. So could that kind of a clause be a security interest? In my view, that sort of a clause will not ordinarily be a security interest. There is a recent Australian decision which supports this view, the case of Bel Air and Roselink Enterprises, a 2020 decision of the West Australian Supreme Court. The clause in that case said that any goods left on the land were deemed to be abandoned, and the landlord could charge the tenant for the costs of removing them. Now, Master Sanderson's reasoning there as to why that clause was not a security interest was because it did not secure performance of any obligation. Respectfully, I agree that a clause that deems goods to be abandoned does not secure any obligation. However, I don't know if you can use the same reasoning in a clause like that in Jayfield, which we looked at earlier. So where the lessor has a right to remove goods and then to sell them to cover the costs of doing so, it seems to me that that does in fact secure an obligation. Namely, it secures the lessee's obligation to remove the goods from the premises once the lease ends. However, there is still a strong argument that that clause, and thus that the clause in Jayfield, is not a security interest. And the argument there is that the right to remove and sell goods left on land doesn't create a recognised property interest in those goods. So in other words, it's merely a personal right, and thus it can't be a right in personal property, which is required by Section 12(1). This does, however, raise a somewhat more unsettled question as to whether a right can be less than a recognised property interest, but still constitute a security interest. And here it's necessary to flag that there are two views. The first view comes from some overseas cases where interests which are not property interests have been held to be enough to be a security interest under the Act. And in particular, I'm thinking of the Supreme Court of Canada's decision in Case Populaire, where a flawed asset arrangement was held to be a security interest, and also a New Zealand decision, McCloy and Manukau Institute of Technology, where step-in rights were held to be a security interest. And that was the case despite the fact that neither of those interests would have been considered to be a recognised property interest at general law. The alternative view is that a right must be a recognised property interest to be a right in personal property and thus to be a security interest under section 12.1. I do think it's worth flagging that it seems most Australian commentators do seem to take this view. And that's the view that's also taken in the statutory review of the PPSA, which also suggests a number of amendments to the Act which are in line with that view. So coming back then to this make good clause issue, in summary of that last point, it's probably the case that a make good clause does not give rise to a security interest, either because it doesn't secure payment or performance of an obligation, or because it doesn't create a recognised property interest. However, this does remain somewhat unsettled, and it was not determined conclusively in the case of Jayfield. Moving on to the second key takeaway. The second thing that I want to talk about concerns consensual property interests and how this affects the priority regimes within the PPSA. So in short here, the PPSA contains two sets of mutually exclusive priority regimes for competitions that involve a security interest. The first, that I've called priority regime number 1 on the slide, concerns competitions between two security interests. Now, in these competitions, the priority rules are thought to be exhaustive, and they usually turn on who perfected their interest first, which often turns on who registered the earlier financing statement. They might also turn on the nature of the security interest and whether it's a PIMSI or a purchase money security interest, and also the way in which the interest was perfected, noting that where a security interest is perfected by control, it will gain super priority. So that's priority regime number 1. But then priority regime number 2 concerns a competition where you have one security interest, but then one non-PPS interest. And that second priority regime is a non-exhaustive regime. So there are some rules in sections 73 to 74, and that of course includes the rule in 73.1, which we looked at in a lot of detail earlier. But where those rules don't apply, a priority competition might still be resolved by reference to the general law priority rules. Now, how does this link to the two cases? Well, in the first case we looked at, Jayfield, because the equitable lien and statutory rights to dispose of property were non-consensual, that meant they were not security interest. So if there had been a priority competition there, it would have been governed by what I've called priority regime number 2, because there would have been a non-PPS interest as well as a security interest. In Tasman Logistics, the second case we looked at, a consensual right was treated as a non-PPS interest. And that meant that the court applied priority regime number 2, and in particular section 73.1, to confer Tasman with priority in that case. Respectfully, in my view, the contractual lien in question should have been characterised as a security interest, including because it was a consensual right. And this means that priority regime number 1 should have applied, and thus that section 73.1, which is in priority regime number 2, should not have applied. As a question of statutory construction, I would turn to the wording in section 73.1, which requires that the interest arise by operation of the general law. And in my view, this means that the interest must arise non-consensually. Such a construction means that section 73.1 could not apply to competitions between two security interests. And this means that it could not contradict the priority rules that otherwise exist, and it prevents it potentially undermining their purpose. Now, turning to the last and perhaps happily the briefer practical takeaway, I want to talk about some kind of broader practical takeaways for practitioners. And there are really just 2 points that I want to make here. The first that I think comes out of these two cases is the importance of being on the lookout for consensual interests with security functions. If both of those features are met, it is possible that there may be a PPSA security interest. The second is if something might be a security interest, then the most prudent thing to do is make a registration on the PPSA just in case, because you don't want to find out that something was actually a security interest at the same time that you find out your client has lost any rights in the property because there was a failure to register. So if in doubt, best to register a financing statement in respect of the property. That is all I have for today. Thank you for your time. Back to Jason.
Thanks very much, Adam. I guess I would just add a slight amendment to what you just said there in terms of if in doubt, register. If in doubt that you have a reasonable belief that you might have a security interest in the future, then you should register.
Yes.
Because of course, if you're making registrations when you don't have a reasonable belief, then you might get fined, although I'm not aware that anyone's been fined with that as yet. And I'm not holding my breath that anyone is going to be fined for that in the near future. But, you know, that is what the legislation says. Nick,
so Section 151 of the Act.
Yep. Thanks very much, Adam. Nick, would you like to share with us your experience of some of these PPSA disputes? I can see some of the comments that have been posted up in the Q&A box. Jim Johnson, the barrister, for example, says that, you know, what Adam's been talking about, these sort of things are going to come up in logistics matters quite a lot. Have you got any experience with these types of matters, Nick, or other recent PPS case examples that you'd like to share?
Look, thanks, Jason, and thanks, Adam. That was quite nice. I'll borrow your slides later for next time we're on. In terms of our experience in the commercial space, I do a lot of banking and finance transactions, auto financiers and the like, and watching vehicles move around the country is the most fascinating thing, and then watching liquidators promptly chase them. When you're looking at this sort of area, you're seeing a lot of different liens. You're seeing consensual liens, you're seeing one-sided liens. And for practitioners, there seems to be a little bit of disregard for how important that can be when you're looking at this type of thing, especially when it comes to the fairly common example of you have a company goes into liquidation, a whole bunch of their vehicles are out on the road. They end up with smash repairers because the borrower promptly abandons them all because they're in liquidation. So of course they're going to just leave them wherever. And then of course, if you're acting for a secured party, you say, okay, we've finally found the vehicle. It's off at Bob's Mechanics, and Bob's, the mechanic, has decided to charge you $40,000 in storage fees. Or at least would like to. And then you need to really look at that and say, is this actually something? Is this a valid repairer's lien as distinct from a storage lien? And it's funny that Adam's talked about two Victorian cases, because the state legislation when it comes to charging storage costs is quite particular. And I believe it's the Victorian Act, which also has, it actually references the PPS priority regime. So when you go to the 73(1) section, it talks about is not provided for by another statute. I believe it does. Now, hopefully I'm getting my states right, because I have a wonderful summary sheet not in front of me of all the jurisdictions. New South Wales, I believe, does not. And then this, of course, creates a difference between the two states. And of course, when you have vehicles driving across state borders, we'll have fun with that. Go call your lawyer. And figure out which jurisdiction are we applying. Your company's in Victoria, your car's now in New South Wales, the mechanic's in New South Wales. Assumably it will be New South Wales law, but you're going to have a bit of fun with all of this. It's not a pleasant experience, and it's quite expensive too. What I'd also say, another common thing we're seeing, especially with insolvency practitioners, and this has happened for us recently, is you need to get back to basics with what's actually going on. Adam's talked exhaustively about the idea of a consensual agreement, in this case, in some lease agreements and the like. You also need to look at the very basic nature of what was the contract to begin with. And insolvency practitioners, I know, are very quick to run to 267 and 588 FM, because those are the provisions, and that's 588 AM of the Corporations Act. Those are the provisions where you're looking for, is a security interest perfected, and if it's not, does it vest in the liquidator? Essentially the casino arms on the table, grab all the chips provisions, which some commentary has suggested is quite unfair, but I'll leave that for another session with Jason. Queue it up for another 5 webinars. But what's interesting about this is often it's because of some of the minutiae of the Act, some of those peripheral issues that Adam's sort of mentioned. The other one is the existence of trusts and this whole fiasco of registering against trust ABNs. Now, we've seen that very quick to point out that a trust exists and try to assert that, therefore, your registration is defective if you haven't registered against an ABN. But as we say, you've got to get back to basics and look at the actual agreement and say who is actually contracting to this agreement. If we have a company, just a company, no other capacity stated, contracting with a financier, then you need to look at that in the context of the security registrations that are made. For example, hopefully your secured party has made those against the ACN of the company. Just because a trust exists does not necessarily mean you've contracted with the trust. And for those who are aficionados with the regulations, the PPS regulations, you're looking at paragraph or section 1.3 and 1.5, which talk about the registration details you need to use. In that case, as I mentioned, you need to look at who you're actually dealing with, because it's very quick for people to read a few articles online which talks about this wonderful provision where if a trust exists and an ABN exists, then you can have defective registrations. And in that case, you can try to take everything, but you need to look at those first principles as well, which sort of, I know that's a bit of a segue, but coming back to the main topic for tonight is also when you're looking at what is my lease containing, you know, what is my agreement with the other party? Is there a lien? Is there not? Is it consensual? Does it have a very nice provision which actually says this is a PPS security interest? That's usually a good start. Obviously, a little more analysis sometimes required. It's not perfect, but you'll see a lot of leases these days, especially for property, will have a PPS clause. And I'm not sure if a lot of landlords realize what that is. And arguably, even if you do have that in your lease agreement, and usually they'll say something like, well, we can register this, but they don't register it. So there's a question as to why are you even having this provision there? There are timing requirements for your registrations. Especially if you want to assert things like PIMSs. As we know, there are very specific requirements around that. You're looking at 15 days for your PIMSs and about 20 days for your other registrations. And then, of course, the 267, 588 provisions, you're looking at those wonderful 6-month periods if you don't perfect in time. So there's a lot of timing that you need to be acutely aware of. So I'd say those are some of the exciting issues. We are indeed having an interesting court fight at the moment. I'm sure the 140 participants here, someone knows about it, about a company that's gone into liquidation. And there is an interesting question about transferring of collateral between a company group that's gone under and what that means for when you need to register your security interests. How does the PPS deal with a transfer of collateral, re-registration, and so on? It's got everything. It'll be very exciting, we hope to read. And hopefully the judge offers us some clarity on the issues, which I think in a lot of the commentary and indeed the review of the Act have suggested that is somewhat lacking.
Okay, thanks very much, Nick. Now we've had a few questions, so not sure if we'll get time to go through all these, but there's certainly a few. So I might start with Lindsay Power's question, and this is specifically for you, Adam, about the Jayfield case. So Lindsay asks, was the judge correct in accepting the argument that no security interest exists until the right to seize the goods and store them is exercised? If that's correct, no perfectible security interest will vest until the grantee does something to enforce, which Lindsay doesn't think is right. Do you have a comment on that?
So I think the preferable way to resolve that issue is essentially to ask, does Australian Comfort Group have a recognised property interest at all? It does not have a recognised property interest within that principle of numerus clausus, and thus it can't have a security interest. I think to some extent that kind of might explain perhaps my tentative preference for the view that a security interest must be a proprietary interest, a recognised proprietary interest, in order to fall within the meaning of section 12.1, contrary to the Canadian case populaire case and the New Zealand case I talked about earlier, because the alternative view might lead you to this kind of very tricky issue. Whereas I think if you interpret the words in section 12.1, an interest in personal property, to mean a property interest within the meaning of the general law, then essentially you can avoid this really tricky issue which you've raised altogether.
And Ian Davidson's asked in relation to the Seaco and Tasman case, did Seaco argue that Tasman had a security interest, or does the concession that section 73 applied mean that Seaco clearly never argued that?
Yeah, so it's very curious. I've read the case very closely several times. There's just no reference to the proposition that Tasman might have held a security interest at all. It seems to have just not been argued. And then obviously the concession, which is expressly made reference to, is that the interest was one that arose by operation of the general law. I do think looking only at 73.1, that's a kind of very easy conclusion to draw, because you might say by operation of the general law means a contractual right. But I think the preferable view is that the word by operation of the general law means something that arises automatically and non-consensually, in which case it does not include a contractual right. But to more directly answer your question, from what I can tell, it doesn't seem to have been argued at all.
Okay, we then have a question from Mark Brabazon, who's asked, suppose that a solicitor retains a barrister in the usual way on behalf of a client and agrees to pay the barrister's fees. The client deposits money in the solicitor's trust account. The solicitor has a lien on the nature of an equitable charge over that money and may resort to it to pay the barrister's fees. Does the barrister have a security interest? Does the analysis change if the solicitor and client agree with the barrister that money in trust for the client is charged with payment of the barrister's fees? I think that's a question to both of you.
I'm happy to jump in for the first part. As to the first component, I assume when you mean the solicitor has a lien in the nature of an equitable charge over that money, that you're referring to the general law solicitor's lien. That is, of course, an interest that arises by virtue of the solicitor-client relationship. And even though it seems to have originated out of the common law possessory lien, statute now extends it so that even though a possessory lien would usually only apply over goods, the solicitor's lien can now apply over money held in trust. Now, in that sense, the solicitor's rights to the money held in trust would not be a security interest. And another interesting thing to note is that that right could actually be conferred with priority by virtue of section 73.1, which we looked at. In my view, there's actually no good policy reason for that. And I've written on it in a journal, a forthcoming article in the UNSW Law Journal. So I believe that answers the first part of the question. The solicitor's rights would not constitute a security interest. Does the analysis change if the solicitor and client agree with the barrister? Nicholas, did you have any view on that or on the second component of the question?
I mean, I suppose to what end? There's an old saying that always pay your barrister and always pay your barrister. There's a reason why barristers will retain solicitors and they won't retain they won't engage with the direct client, because the barrister always wants to be paid and they want to make sure that someone will pay them. And if they don't, there's a very angry letter from barristers' chambers to the solicitor's firm and ultimately ends up in Lawyers Weekly, if not the court. I haven't encountered a situation where a barrister and a firm would come to some agreement about money held in trust. It would simply be, these are my fees, you're required to pay them within 7 days, thank you very much. It's fairly clean cut in that regard, because either the money will come from trust, essentially to make sure that you get paid. And the barrister will always get paid because their contract is with the firm, and not necessarily even just the solicitor, it'll be with the firm. So it's the firm's obligation to make sure that that is paid. And, you know, if a law firm is going under, then I suppose there's some bigger issues.
And Nicholas Mirzai's made a comment on the chat there saying, this would only change if the contractual term ousted the statutory security. Okay, so I'm just going through the questions. So Lindsay's asked another question. This is for Adam. If a clause says that property is deemed to be abandoned, does not create a recognised property interest, could you nevertheless argue that it impliedly transfers property in the goods to the lessor?
Now, there is a case which I'm in fact teaching next week in a tutorial, although I can't recall the name off the top of my head. It's a Victorian case concerning the nature of interest in goods, abandonment and ascertainment. My understanding of Australian law in this sense is that there are two quite distinct steps where abandonment is one and then ascertainment in order to gain title, which happens by way of taking possession of the goods, is a second step. So the way I would view it is that abandoning goods is not enough in and of itself to transfer title to the lessor. It's the lessor's subsequent act of taking possession, which then allows it to effectively gain title. And so in that sense, I would say there is not a transfer of title within the meaning of the abandonment, and thus it wouldn't create a security interest.
Okay, and then we have a question from Peter Shepherd. So this is about the Jayfield case. And he's asked, why couldn't the landlord interplead?
Yeah, I think that is a great question. I think obviously I can only speculate, but what the landlord Australian Comfort Group did there is it commenced proceedings seeking statutory orders to essentially get rid of the goods. So I think that had a quite similar effect to if it would have interpleaded. The ultimate issue that really came up is the fact that whether or not it interpleaded or it sought orders under statute just to get rid of the goods, it was still stuck with possession of them until that got resolved by the court.
Probably worth mentioning, I'm not sure if you mentioned, Adam, that they were really keen to get rid of these goods. We're talking about big machines and it's a big warehouse. They couldn't do anything with it for, what, 2 years, I think, since they started? I mean,
yeah, I think the issue in particular was Australian Comfort Group, the lessor, was actually a sub-lessor under a slightly longer lease. And so it was left in a position where it was not commercially feasible for it to grant another sublease because the nature of its own interest in the property only had, I think it was under 2 years that it had left. And it's very hard to find someone to take on not only that short-term lease in that commercial context, but also to take on a lease where there's a bunch of goods sitting in the property which you can't get rid of. And so there is discussion in the court's judgment about Australian Comfort Group potentially fielding another offer to lease out that property. But the court then says that that offer seemed to have fallen through. And it does seem to link that to the fact that the goods were left there and essentially stuck there.
Okay, so we haven't had any more questions come up. So I think we might draw it to a close there. I guess I'll just share my final thoughts on the discussion. The biggest takeaway that I've taken from this discussion is really just a reminder for everyone, particularly for those who are business people rather than legal practitioners, that the PPS is not a complete code. The PPS is effectively operating on top of the commercial relationship and the legal rights that exist between the parties. And whilst if we're dealing with, as you said earlier, Adam, a competition between, a priority competition between PPSA security interests, and obviously the Act is going to apply and the rules under the Act apply, we're not always dealing with that. And it's easy for parties to look at registrations on PPSR and say, oh, well, you know, there's a problem here, or I've got rights because of this registration. We need to remember that the Personal Property Securities Register is a notice board. It in and of itself confers no rights. Just anyone can register, as we've seen. And Jim Johnson posted a comment earlier about the Garrett case, where Mr. Garrett was was recording registrations against, you know, all the judges of the federal court and the High Court, etc. So just having something registered, that is almost neither here nor there. If you combine it with the other elements that you need for perfection, then you might have some enforceable rights. But we always need to bear in mind, what is the relationship between the parties? What are the rights that are conferred by the underlying documentation? And then the PPSA might be an overlay on top of that. I think that's easy to forget. We get so caught up in applying the sections in the PPSA, we forget there's actually a lot of steps you need to go through before you even get to the PPSA. What exactly is it that we're dealing with? What are the rights? And it's only, as you've said, Adam, it's only where those rights fit within that criteria for a security interest. That's when the Act is engaged. So, you know, the key takeaway is go back and look at your documentation.
I think if I can kind of jump in off that point as well. I know there is definitely a perception that the PPSA is often thought of as this very kind of technical piece of legislation, and certainly common lawyers tend to go, something technical must mean something dull. And I can't deny that the PPSA is highly technical, but that kind of does raise something that I think is quite important as well, perhaps just because I'm a bit of a nerd about the PPSA and I find it terrifically interesting, which is that even if you're not into the extremely technical aspects of it, the Act itself raises these big conceptual issues, both in and of itself and issues that tie into the general law. And so I think that is something that really can be quite inherently interesting. And so being somewhat less on the technical side, which Nicholas and I know Jason could certainly speak much to more than I could, I find these broad questions, what is a property interest? Must something be a property interest to be a PPSA security interest? To be extremely interesting at this somewhat higher conceptual level. And I think it's quite fascinating that the Act both raises these questions and requires this immense attention to detail from the more technical side as well. So it'll be interesting to see those conceptual issues come up and continue to be litigated over the years, along with the much more technical side of stuff where we've seen a lot of Section 580M, 588FM, 588FL under the Corporations Act, etc.
I agree. It's such a technical area. If only there was a guide that people could look to. If only there was a guide that people could look to navigate through the PPS. So the book that Nicholas and I published late last year, which people can have a look at.
That would be the slightly other Nicholas, the Mr. Mirzai in the commentary.
Mr. Mirzai, yes.
I would love to take credit for it, but I think he's got a bit more experience in this field, just a bit.
Yes.
But if I can echo the words of, and bless, I've forgotten her name, but my second year contract law lecturer, it's simply go through the steps, start with the basics, because if you don't, you will end up falling over later. And the number of times that security interests have fallen apart because they've contracted with the wrong party, and the registration collapses because there's nothing securing it. It secures nothing, as our property law lecturer would say. It's fascinating that everyone gets very excited about the PPSA, and then they say, yes, but you've forgotten the first 2 or 3 years of law school. This comes later. You need your foundations. And it's fascinating. I've seen one case where they go back the other way. And so certain sellers of property have in their terms and conditions that they won't sell things while encumbered, certain auction houses and so on. And this is despite the fact that the PPSA has provisions as to how a secured party can sell something by public auction once they've repossessed it. And of course they won't budge because they say, oh no, well, we couldn't do that. We don't want to be exposed. So it's very interesting that a lot of misunderstanding can lead to a lot of technicality when there isn't necessarily warranted.
So thanks again to Adam for the fantastic presentation. Thanks so much, Nicholas, for your comments. And thanks to everyone who's attended tonight for the great questions and comments that we've had throughout. No doubt we'll have some more PPS-themed webinars later in the year through the Ross Parsons Centre here at Sydney Law School. Like I said at the start, there'll be a recording of this that'll be made available to everyone who's registered, and also that will be posted up on the podcast page and the YouTube page for Sydney Law School. The next Downtown Law and Business webinar that we'll be running through the Parsons Centre will be on the 31st of this month, where we're going to change tack, or still in the finance realm. We're going to be discussing the extent to which banks should have a right to, an obligation rather, to treat customers fairly. And we have a scholar from University of Wollongong who's been doing some comparative research looking at those types of statutory obligations that have been introduced in other jurisdictions, particularly in England. And we'll also have Nicola Howe from Queensland University of Technology as a commentator. So I haven't posted up the details for that yet. We'll do that probably tomorrow. So look out for that. And thanks again to our presenters, and enjoy your evening, everyone. Thank you.